So here I am, everybody. Lonely without you, but that is okay. I will make it through. You will make it through. And I hope we'll have some good learning. I'm actually really excited about this empty classroom and the empty learning environment in which I find myself, because I think I have found a strategy to overcome some of the limitations in terms of my commitment to constructivist learning that is presented by doing these videos. You guys will tell me, before we get started, I want several things to happen. Number one, you should have downloaded the accompanying PowerPoint. That's just to make sure you're able to clearly see any of the graphics that are up here, as you should be very well accustomed to seeing by now. There's not that much substantive there. But to make sure you can see it and you're not concerned about that, make sure you download that PowerPoint. Number two, you should have your printed worksheet with you. Your printed worksheet you should have with you actually printed out. I am going to ask you next Tuesday, the next time we see each other, to show me your printed worksheet, and so you should have your printed worksheet sitting right next to you while you listen to this class. And then finally, you should have 2 different color pens. Let me repeat that. At least 2 different color pens. When I was a law student, I hand wrote my notes, primarily because that's what I wanted to do, but it turns out it's actually better for learning, at least according to the evidence that we have available today. But I didn't just handwrite my notes. I had a whole rainbow of colors that I used to handwrite my notes. I used black for black letter law. I used blue for general notes and explanations. I wrote in red the questions that I needed or wanted answered, and I added my own commentary and what I thought were really cool insights in purple. I also carried green, pink, and other shades like, teal. I spent a lot of money on colored pens. I also had highlighters in basically every color you could find. Sometimes I would have metallic pens as well. And it was all just designed to best memorialize my thinking during class, but it kept me doubly engaged because I was flipping through pens and making sure I was characterizing what I was hearing and what I was thinking and what I wanted to write down on my page in a way that made sense based on my color-coded scheme that I used. You don't need to be that detailed, but you do need at least 2 colors. And I'll tell you when to use what I'll probably say color 1 or color 2. In case I forget sometimes to tell you what color to use, you can basically tell yourself this. Put yourself in color 1. Put yourself in color 1 and put me in color 2. Yourself in color 1 and me in color 2. Needless to say, you should have a lot more color 1 than color 2. If you choose as your 2 colors black and blue, as many of you will because those are probably the most accessible for you. If you choose black and blue as your 2 colors, please use black for Professor Yule. Use black for me and use blue for yourself. There's actually science behind that. But I won't go into that here. Use black for Professor Yule and blue for yourself if black and blue are your colors. Indeed, if black is one of your colors, use black for Professor Yule. If black is one of your colors, use black for Professor Yule and use the other color for yourself. Okay, you also will find at the end of this lecture there is an assignment. An assignment, that means a submission online through Blackboard that I will expect you to complete. It shouldn't take you very long, but there is a submission requirement. You will find that submission under assignments, and it'll be in the module for weeks 10 through 12, which is called removal. Okay? All of this will be referenced in updated prep tasks. All of this will be referenced in updated prep tasks. Okay, let's get started. as we said yesterday, everything that we have done so far in this course has been about, or can be characterized as being about, two things. Identifying the different paths one can take to enter the U.S., either as a non-immigrant or an immigrant, and two, exploring strategies to determine which path makes the most sense, which is the best, given the circumstances and goals of the non-citizen. Right? That's what we have done so far. We now, let's see, I would have preferred not to do it that way. We now turn our attention away from paths into the United States, and we start looking at some other questions, issues that are of vital importance. Roadblocks, barriers. In other words, instead of asking, how does one get into the United States, we are going to start asking, what keeps you from getting in, and how you can be expelled, or how one can be expelled, how one can be kicked out of the United States, right? How can you get kicked out? We commonly call this deportation. Deportation. We call this deportation. Wait, Professor Yule, if we call it deportation, why have you written the word removal? Well, it's an important note to make on our terminology. Out in the world, and even amongst lawyers, you will commonly hear the term deportation. And until 1996, the term deportation was perfectly accurate. Okay? And deportation was the procedure used by the United States government to expel people from the country, to kick people out of the country. Similar to deportation, exclusion. Exclusion was the procedure for keeping people from entering the U.S. That is, deciding whether or not a person could, as a general matter, be allowed to come into the United States. Right? So exclusion were the roadblocks and barriers, and deportation was the expulsion before or until 1996. But under the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, that's IRA, we've talked about it before, and IRA amended the INA. Deportation and exclusion actions were combined. They were combined into one kind of procedure. And that one single action became known as the removal proceeding. The removal proceeding. That idea, the removal proceeding, is what we need to know about. It's what we need to know, but just like it's helpful to know what the INS is, right? The legacy INS, Immigration and Naturalization Service, it's an organization that doesn't exist anymore and was replaced by various wings, right? From CBP to ICE, right? Just like it's helpful to know as we look through old precedent, as we look in old but still enforced rules, we want to know the origin of the term and the meaning of the terms deportation and exclusion. But today, there's no such thing as deportation proceedings per se. They are removal proceedings, and that combines both determining whether someone is excludable from the United States, can be excluded, and traditional deportation. Now that we know that the current term is removal, what does it mean for someone to be removable? What does it mean for someone to be removable? Okay? What does it it mean for someone to be removable? I would like you to stop right here. I would like you to stop right here. Okay? And we're going to get this idea sort of clear in our heads right from the get-go. Removable. There are two ways for a non-citizen to be removable. Okay? A non-citizen is removable if that non-citizen is inadmissible or if that citizen is deportable. Right? An individual is removable if they are either inadmissible or deportable. I want you to stop right now. Push pause. Don't push pause yet. Let me finish my sentence and then push pause. But I literally do want you to push pause once I give you this instruction. Okay? I want you to find the sections of the INA relating to inadmissibility and deportability. You can give yourself 10 personal edification points if you can recite those sections off the top of your head. But assuming you can't, put me on pause. Write down right now in your notes the section of the INA relating to inadmissibility and the section of the INA relating to deportability. Okay? Put me on pause. That was me giving you time to put me on pause. I hope you put me on pause. All right. Hopefully I'm coming back from pause now. I always stop a little while because you could have been not sitting right next to your pause button. So I'm giving you time to give pause. Whenever I ask you to pause, I really do mean to stop and put me on pause, and I will try to give you some filler so you have time to put it there. Let's repeat really clearly. An alien, a non-citizen, is removable if that non-citizen is either inadmissible or deportable. Okay? Inadmissible in the case of a non-citizen who has not been admitted to the United States, and deportable in the case of a non-citizen who has been admitted to the country. Okay? Now, let's do some comparative analysis. And your notes, your note worksheet gives you a nice comparative block to begin. All right, let's figure out. The term removable tells us inadmissible or deportable. Inadmissible or deportable. We are lawyers. We know that that's not enough. We need to figure out what those terms, inadmissibility and deportability, mean. All right? You just identified two sections. I don't know why you're messing with the bull, getting the horns. You just identified two sections of the INA. I want you to stop and go back, and now I want you to read those sections. Okay? Again, I just said stop and go back and read them. That means put me on pause. Put me on pause. Okay, I'm assuming that you've put me off of pause, you've taken me back off of pause. What I would like you to do now, is in your own words, based on what you just read, write down to whom the category of inadmissibility and the category of deportability applies. Right? Who do these two categories apply to? Right? Explain, right? Who is subject to which definition? Who is subject to which definition? Put me on pause. All right, you should have brought me back now. And I'm going to use some of my words. You get 0 points, by the way, if you just copy down my words. You should have been writing in your own color. That's your blue if you are using black and blue. Should have been writing with your own color. And it's just my lay definition. And I want you to also have a lay definition. In your own words, a definition of these concepts. Here are mine. I said inadmissibility. It means you're not permitted to be admitted. You're prohibited from entering. Right? Not all of these are my own, excuse me, not all of these are my own words. You're ineligible to receive visas and ineligible to be admitted to the United States. That's what it means to be inadmissible. Who do we think this should apply to? Who did you hypothesize that this applies to? Right? Hypothesize. Intelligent guess. Intelligent supposition based on your reading of the law. What about deportability? Right? You're subject to ejection or expulsion from the U.S. Your authorized status is revoked. Right? These are just different ways of describing our layman's understanding of a term. Right? Inadmissible, can't be admitted. Right? Deportable, can be deported. What does it mean to deport? To kick someone out, to take away your status, to expel you from the country. All right? Now what I want to do is keep moving forward, right, and ask another core question. Right? Another core question. We've got these two categories, inadmissibility and deportability. When are they checked? When are they checked? That is, when do we ask whether a non-citizen is inadmissible or deportable? At what point in the game do we ask whether the non-citizen is inadmissible or deportable? Put me on pause again and brainstorm this. You have space. Every time I ask you to put me on pause, there's space in your notes where you should be writing likely in blue or in the color that you've chosen for yourself. Okay, so put me on pause and do that. Okay, so the inadmissibility language. The inadmissibility language can go back, right? You identified where this concept appears in the INA. And in that section of the INA, you get this great language. Aliens who are ineligible to receive visas and ineligible to be admitted to the United States. Okay? That gives us a great reminder that non-citizens who seek admission, right, to seek admission to the United States may be screened on several occasions. In fact, when do we check admissibility? Anytime a non-citizen seeks an immigration benefit. Anytime a non-citizen seeks an immigration benefit, we ask whether or not that individual is admissible. Now I want you to take to your brainstorming and add at least 3 specific times. 3 specific times when this would occur. Add that to your list. 3 specific junctures when the question then about inadmissibility would be asked. Now, based on your understanding and your brainstorming about deportability, we should see that that question is asked less frequently. Right? Let's go back just for a second. And we see subject to ejection or expulsion. Right? In order to be ejected or expelled, you have to be in the United States. So we know that this question is going to be asked less frequently. Right? There are fewer occasions to ask about deportability than there are to ask about admissibility, but we see that there are repeated and several occasions. It's a great reminder again that non-citizens are screened a lot of times. Non-citizens are screened a lot of times. They're screened with regularity, and we ask these questions, whether they are inadmissible or deportable. If they are either one of those two things, then they are removable. If they are either one of those two things, then they are removable, okay? But where is the line, right? I have them set up here, verses, right? In your notes, there's two columns, an inadmissibility column and deportability. It's a comparative analysis that we're thinking through now. So where do I draw the line? Where do I draw the line? This should be helpful. And I will post a link to this BIA decision in our shared resources wikis. But in this case, the matter of Quilantan, the BIA explained that what really matters, what's really important in figuring out the difference between inadmissibility and deportability, and I will tell you, this is a legacy issue. It used to be a much more complicated question. After 1996, we pared these questions down. And this is even why the BIA needed to weigh in on it, to clear up that confusion that was legacy. It was historical confusion, because whether or not a person was deportable or excludable was a much more important distinction, and a more difficult to draw distinction. Today it's not so far. What matters is whether the non-citizen has gone through the process of getting admitted to the United States. Did they go through the process of getting admitted? Fill out the application, show up, get inspected, and then be admitted? If that happened for the non-citizen, they are deportable, not admissible. Right? They are deportable, potentially, not inadmissible. All right? If they didn't go through the process of getting admitted, then they are inadmissible. This is an important note. It doesn't matter, right? It doesn't matter if we would conclude, if we had been the individual, if we had been the CBP officer, if we had been properly applying the law, right? The person wouldn't have been admitted. Okay? It doesn't matter if they should have been admitted. What matters is whether they went through the process and were admitted. If they went through the process and were given admission, right, then the individual is subject to deportability grounds. And if they were not admitted, then they are subject to inadmissibility grounds. Okay? Any non-citizen not admitted is subject to inadmissibility grounds. Once you've been admitted, deportability. That's where we draw that line. Okay? That's where we draw that line. Okay? The key question is admission. Okay? And you can see this explanation from the BIA makes sense if we look at the definition of admission, which is in Section 101A of the INA. Let me find it. Section 101A of the INA. Section 101A, not A3, not A15, right? I'm highlighting terms that you should be familiar with. 101A3 is the definition of the term alien. Number 101A15 is our definition of immigrant, which also embeds in it our definition of non-immigrant. Here it is. Section 101A13 of the INA This is also 8 U.S.C. 1101A13. And subsection capital A there explains the term admission and admitted mean, with respect to an alien, the lawful entry of the alien into the United States after inspection and authorization by an immigration officer. Okay? You were admitted if you were inspected and given authorization to enter the country by an immigration officer. Doesn't matter if they did it in error. Okay? And so this makes sense how we draw the line. It's now very simple. Okay? It's now very simple. Let's try some examples. Okay? Frank enters the United States on foot, crossing our northern border with Canada. He's in Vancouver, goes in Vancouver, Canada, goes to Vancouver, Washington. He does not go through the normal channels of inspection. We call this EWI, enters without inspection. So Frank is entered without inspection the United States from Canada. Okay? Which category is Frank falling into? Is Frank deportable? Is Frank inadmissible? Is Frank inadmissible? Is Frank deportable? It's easy. He entered without inspection. By definition, he has not been admitted, and therefore, Frank is inadmissible. He's not deportable. He's inadmissible. Is Frank removable? Yes, your head should nod. Why? Either of these two, either of those two categories make you removable, right? But Frank is inadmissible, not deportable. What about Sally? Sally is an F visa holding student at K-State. Okay? Because of Sally's grades, she is expelled from K-State, but she stays up in Manhattan. Okay? You will recall that most F visas are granted for that D/S duration of status. When did Sally's status end? Upon her expulsion, when she is no longer enrolled in her program at K-State. She stayed anyways. What do we call this? What is our immigration language for this term? She overstayed her status. She overstayed her admission. Is Sally inadmissible or deportable? Well, I just gave it to you. Sally overstayed her admission. She's not inadmissible. She is deportable. Sally's not inadmissible. She is deportable. What about Gregor? Gregor is a non-citizen. He entered without inspection in 1981. Gregor entered without inspection in 1981. That means he's lived in the United States for 25 years. Not 25, I wish. For 35 years. Gregor has lived in the United States for 35 years. Doesn't matter how long the individual has been in the United States. He was never admitted. And so he's inadmissible. Gregor is not deportable. Now, how long an individual has been in the United States, the length of their overstay, all of those things. So the time in the United States can come to play, but as a threshold matter, that's not true. What about, here's another one. What about Jose? What about Jose? Jose is a lawful permanent resident. Jose is a lawful permanent resident, and Jose is from Nicaragua. And Jose goes to Nicaragua, and he's in Nicaragua for 18 months. Jose is in Nicaragua for 18 months. Okay? And after 18 months stay in Nicaragua, he comes back to the United States. Remember, Jose is a lawful permanent resident. Okay? Okay. Comes back to the United States, let's say he flies to JFK. John F. Kennedy Airport in New York, he lands. He's at the border. He's at the border. Okay? Well, Jose has been gone for 18 months. Might be concerned, right? We're asking, remember, we asked these questions about inadmissibility. Every time a person seeks to come to the United States, is Jose seeking admission? Is Jose seeking admission? Let's go back. Let's go back to the INA. Maybe I shouldn't have closed it, right? Let's go back to section 101. Little a 13. And what I read was little a 13 big A. Let's read little a 13 C. An alien lawfully admitted for permanent residence in the United States shall not be regarded as seeking an admission into the United States for purposes of the immigration laws, except in limited circumstances. That alien has abandoned or relinquished the status, has been absent from the United States for a continuous period in excess of 180 days, has engaged in illegal activity after departing the United States, has departed from the United States while under legal process seeking the removal of the alien from the United States, has committed an offense identified in section 212 of the INA, is attempting to enter at a time or place other than as designated by immigration officers. Okay? Jose, we said, had been in Nicaragua for 180 days. Okay? Is Jose seeking admission at the border at JFK? No. No, because that's not in excess of 180 days. Now, the list of exceptions was pretty long. But recall, it'll be the government's obligation to prove at least one of those exceptions exists. So, based on what we know about Jose and his travel to Nicaragua, Jose may be deportable, right? We can't actually know whether or not he may be deportable based on what we know about his travel. But if he were, he's deportable, not inadmissible. Why? Because lawful permanent residents at the border are not seeking admission unless one of those exceptions applies. Okay? All right, we're moving steadily ahead. We've seen our categories through examples. Let's get them out sort of clearly for ourselves. Who is subject to the inadmissibility question? If you're arriving, right, when is the question asked? At the border, and crucially when we file the application. Remember, up to now, everything that you've done, it's been there in the reading between the lines. It's been there, we haven't discussed it, in order to be granted, right, any visa or any immigration benefit, you have to be admissible to your status. So you're going to get checked for admissibility at the border, but also when you're filing the application. Okay? You're also subject to inadmissibility grounds if you're present in the United States without ever having been admitted, right, or paroled. That means you're EWI, entered without inspection. What about deportability grounds? If you've been lawfully admitted, even if the admission was erroneous, if you were lawfully admitted, you went through the process, okay? That means you're a lawful permanent resident. you're in some non-immigrant category, okay? You are an asylee or a refugee, right? All of those individuals, or all of those categories of individuals would be lawfully admitted. All right, I want to also get some definitions out of here that we just looked at, right? We looked at INA 101A13 Big A, okay? And Big A tells us what admission is, okay? We can also see in section A13, it's actually A13B, that parole is not admission, okay? And we've got from 8 CFR 1.2, we've got a definition of arriving alien, which just reflects INA 101A13 Big C, which we just read, right? And it tells us that LPRs are not generally in the category. We also have now spent a lot of time thinking about inadmissible and deportable. So these are our key definitions that we now should be able to use just based on our conversation today. The second thing I want to do, that's thing one that we've achieved today. The second thing that I want to do is ask, right? What are we doing? We already asked about the paths into the United States, and we are now exploring roadblocks that prevent us from getting into the United States, even if we've chosen a good path, and ways that we can get kicked out of the United States once we've made it in here. We need to ask some threshold questions, right? As lawyers, what we're going to be asked to do then is determine if someone is removable, right? Indeed, earlier in this course, I talked about the fact that very few people may ask you, right, as a practicing lawyer, it's not as common for you to be asked to find paths into the United States. Only, solely, wholly because if you are practicing in the United States, your clients are likely already in the United States, they have found paths in the United States. It's still important to be able to understand the paths into the United States. One, sometimes individuals will come to you looking for ways and paths that keep them in the United States, right? So you should be thinking your I-539 practice, your I-485 practice. But also, as we determine removability, understanding the paths that could have been taken and were taken into the United States and the potential avenues for staying in the United States is really important. That's why we spent so much time on understanding how you get to the United States. But the main question you might find people asking yourself if you're practicing in this area in the United States, or the main question you might find people asking you is how to determine removability. And we gotta figure out, ask ourselves, what are the threshold questions? What are the threshold questions? What do we ask before everything? Right? This allows us to dig a little bit deeper into what we now just have a really limited set of definitions. We know admission, okay? We know maybe arriving alien. We know inadmissible. We know deportable, right? We know these are concepts that exist, okay? Let's dig deeper. What do we have to do before we do that? Let's ask our first question as we dig deeper, and that's this. To me, you could think that you have different first questions, but how does the government initiate removal proceedings? How does the government initiate removal proceedings? Okay? And now let's look at notice to appear. And I gave you guys some notices to appear to look at. This is actually the sample that the government provides so that you can see what it is. I pulled a notice to appear off the internet. Let's look at it. Okay? You want to remember the notice to appear is the charging document. Okay? The notice to appear is the charging document that the government serves to begin immigration court proceedings. right? It's the charging document. If you've ever done any criminal practice, what is a charging document? It's the document that indicates that some action that is taken, if you're in criminal practice, obviously, it's some action that constitutes a crime. What do we think that the notice to appear is charging an individual with? Well, let's go back. I just gave you a definition of notice to appear. A notice to appear is the charging document the government serves to begin immigration court proceedings. Well, what are the immigration court proceedings known as? Removal. And when is a person removable? If they are inadmissible or if they are deportable. And so what the government is charging an individual with being in a notice to appear is removable. Okay? Now, before we go on and we look more closely at this notice to appear, I want you to put me on pause one more time. I want you to put me on pause one more time. And I'd like you to tell me where we find the requirements for serving an individual with a notice to appear. Okay? Where do we find the requirements for serving an individual with a notice to appear? And I want to figure out where the list of individuals, like who gets to serve this? Right? We talk a lot about the government in this course, but this is actually the first time we're really affirmatively asking the government to do something. Okay? This is the first time we're asking the government to affirmatively go out and do something. Normally, right, in the conversations that we've had thus far, we appear before the government. Okay? And we appear at an appointed place. Well, who gets to issue these notices to appear? Stop, put me on pause, answer that question. I'm asking you to look both in the INA and the CFR. You should always be doing that, but this time I've asked you to do it affirmatively. All right, so I hope you saw that the list of government actors who have the authority to issue the NTA, the notice to appear, the NTA, it's a really long list, right? It's a really long list. We can guess, just looking at that list, we can intuit who most frequently and is most likely issuing these notices to appear. You can even see one particular government agency currently listed. The one that I printed out from the internet, a random one that I printed out at the NTA, still says Immigration and Naturalization Service. Yours says U.S. Department of Homeland Security. Obviously, again, this is why we try to understand a little bit of history. All right, so let's look at the document. Okay, let's look at the document. This is the sample, but what I really want you to look at and think about are the examples that I asked you to look at in your prep tasks. Let's think about them. Okay? We could compare them to the section of the INA that you just identified and see how this form notice to appear, or these form notices to appear, are complying with the provisions of that section of the INA and that elaboration that appears in the CFR. But let's just think about it as well, more broadly. What is the information that's included in this notice to appear? What's the government trying to do? What's the government trying to do? Well, let's think about this. I asked you to imagine yourself sitting in your office and someone bringing this to you. How did they get it? How did they get it? Well, likely the notice to appear was put in the hand of the non-citizen, right? Personally served, or it was mailed to their last known address. Could have even been sent to their attorney if they had a G-28, which is a notice of representation that you file with USCIS. If they had a G-28 on file, their attorney could have gotten a copy. Okay? Simultaneously served, simultaneously used really loosely, is the immigration court having jurisdiction over a matter. Put me on pause right now. Put me on pause right now. And let's imagine that the person has an address in Lawrence, Kansas. What immigration court is going to hear this charge of removability? What immigration court is going to hear this charge of removability? Put me on pause. I'm going to tell you to go to the USCIS website. These things are not actually static. So let's see if we can figure out what immigration court is going to be the one that would hear the charges of removability for an individual whose street address currently residing at is here in Lawrence, Kansas. Okay. All right, we've come back, and I actually really liking this pause game to keep you active in the process, not just passively listening, but actively learning. But let's look a little closer. We see that first the NTA lists the name. It'll also list any aliases of the individual. Okay? It's going to list their file number. Okay? It's going to list their A number or their alien registration number. Okay? It'll generally provide the date of birth of the individual, and you can see up here we've got date of birth. Okay? We've got date of birth up there. And it'll give as much biographical information that it can. Okay? Then it provides the basis for the issuance of this notice to appear. And you get these 3 check boxes. Okay? It either is going to check off 1, you are an arriving alien, 2, you are an alien present in the United States who has not been admitted or paroled, or 3, you have been admitted to the United States but are removable for the reasons stated below. Okay? It's going to check. It's going to check one of these three categories. What I'd like you to do now is next to each of the categories, tell me whether or not, tell me right next to it which aspect of removability would apply to the individual. If the individual is an arriving alien, are they inadmissible or deportable? If the individual is an alien present in the United States who has not been admitted or paroled, are they inadmissible or deportable? If they're admitted to the United States but are removable for the reasons stated below, are they inadmissible or deportable? I want to take just 2 seconds to say something. Right? The first half of this course we spent a lot of time using the term non-citizen, and we will continue that practice. But remember I said that the government doesn't do that. The government doesn't do that. So take yourself back to the long conversation we had about the power of that word. And now imagine that you are an individual who has received this notice, and you are one of those individuals, we can't guess who's going to fall in the category and who's going to fall out of the category, who finds this word to be the equivalent of the N-word, okay? In the document seeking to remove you from the United States, this is how you're going to be referred to, okay? It's a quick reminder of the implications and the power of some of the stuff we've talked about in the past. So anyway, you've now annotated this. And so we see each of these categories just checked off, explaining on what grounds the government claims that you are removable. Then the government will give some explanation. The Department of Homeland Security alleges. Okay? It gives some allegations. It gives some allegations. I'm going to read you the allegations that appear in the NTA that I printed off the internet. Think about the allegations in the NTAs that I asked you to look at. This one says the service, remember it's the legacy INS who issued this NTA. Today it would say the Department of Homeland Security alleges that 1, you are not a citizen or national of the United States. 2, you are native of, this is redacted, and citizen of, still redacted, but that would say a native of some country that's not United States and a citizen of some country that's not the United States. And 3, you were admitted to the United States at some location on or about some date as a non-immigrant, and then it gives the category with authorization to remain in the United States for a temporary period not to exceed, and then it gives some time period. I'm going to say that this person was likely given authorization as a business traveler. And then 4, it says you remained in the United States beyond the same date without authorization. Okay? This is, right, in this example, it breaks it up because that will look different for every single person. This is what it looked like in this NTA. Look at the other examples that I've given you. Okay? Then it says at the bottom of the argument section that doesn't appear in this example, on the basis of the foregoing, it is charged that you are subject to removal from the United States pursuant to the following provisions of law. Notice that even though the legacy INA issued this NTA, it says you're subject to removal. Remember, the INA, the INS was not reorganized into the Department of Homeland Security until after 9/11, 2001. But deportation and exclusion was eliminated and merged into removal in 1996. So that's why there's 2 different time periods going on in this example, for those of you who listened to that closely. Anyways, it says on the basis of the foregoing, it's charged that you're subject to removal from the United States pursuant to the following provisions. Okay? Then it also includes, we're not just reading this for kicks, then it also includes the specific provision. The specific provision under which this individual has been deemed removable. Now, we just said in the example that I'm reading from that the individual was admitted as a non-immigrant and overstayed their admission. So, is this individual being charged as being inadmissible or deportable? Deportable, exactly. And so, what do we have? The section referenced is a ground of deportability. What section did you identify as listing the grounds of deportability? Okay? What section have you identified as listing the grounds of deportability? And what are the charges? Go to that section. Based solely on the charges here. Why would I say based solely on the charges that I read out? These allegations are the allegations the government is going to set out to prove. The notice to appear. What is the notice to appear? It says we're initiating immigration proceedings against you. You have to appear before the immigration judge. And what is it telling us? That it is going to claim, that the government is going to claim to the immigration judge. Right? It's listing specific provisions. It's listing specific provisions of the INA that it is going to claim that were violated. I want you to put me on pause after I read the allegations again and try to figure out which deportability provision is a violation, or for which deportability provision is a violation supported by these allegations. Let me read the allegations one more time. You are not a citizen or national of the United States. You are a native of some foreign country. You were admitted to the United States at some location on or about some date as a non-immigrant with authorization to remain in the United States for a temporary period not to exceed some number of days or date. You remained in the United States beyond a given date without authorization. Those are the allegations. Which deportability provision has been violated according to these allegations? Put me on pause and make a note of that example. Okay, the example is in your notes. All right, now let's continue looking at the sample INA or sample NTA. And what else do you get on the sample NTA? You get the, so we just talked about the nature of the proceedings, right? You also get the factual allegations, right? And the factual allegations, right, will almost always include that, number one, you're not a U.S. citizen or national. Number two, you're a native and citizen of some other country. Number three, that you entered the country on a certain date through a certain city, right? And whether or not that entry was authorized, and if it was authorized, for what period of time, okay? And then, number four, and there may be more than four, but starting at number four is when those allegations become less standardized because they explain why the individual was removable. In the example that we are working with now, different from the examples that I asked you to explore before, it states you remain in the United States beyond a blank period without authorization. Okay? Then, as I said, it's going to list the charges or charge of removability, the provisions. It's putting you on notice. It's giving you, the non-citizen, the legal reason the government believes that the individual can be removed from the United States. Okay? It's giving the legal reason the government believes the individual can be removed from the United States. Then, important, and you should be able to see that this is required, but you should also be you should be able to intuit that it makes sense. Then it gives you the date on which you are required to appear, no less than 10 days from when the notice to appear is served, the date and time where you are supposed to appear to show why you should not be removed from the United States. Okay? All right? Then it is dated. It's going to give you a signature from whoever issued it. Remember, and maybe this is where you give yourself a reference of all of the people who are all of the agencies that are authorized to issue this notice to appear. All right. Now, this is the front. On the back of a notice to appear, there is a long list of notices. Okay? A long list of notices. Okay? A copy of the notice to appear is required to be carried by the non-citizen at all times. A notice about representation. This is really important. If you so choose, you may be represented in this proceeding at no expense to the government by an attorney or another individual authorized and qualified to represent persons before the Executive Office for Immigration Review, pursuant to 8 CFR 3.16. Okay? That's really important. You can have a lawyer. You have to pay for your lawyer yourself. As you start thinking about these proceedings and how they are run and the level of sophistication required to navigate them, you ask whether or not that right, privilege to have counsel, but not right to have counsel, is appropriate. This is a big debate, not just in the area of immigration, right? But immigration is civil, and therefore all of civil law. But in immigration, the debate is very charged because the question is whether immigration proceedings look more and have impacts closer to criminal proceedings or civil proceedings. So it's an interesting conversation that is highlighted in your notice to appear, right? And then it explains how hearings will be conducted, and it also explains what happens if you fail to appear. Okay, we are going to continue to have those conversations moving forward, but before today ends, I want to ask a couple of more questions, okay? Threshold questions. Now we understand what the notice to appear says, right? So threshold question when we have someone walking in through the door is, what the heck is the notice to appear? How does the government start the whole proceedings? What am I looking for? So now we know to look at this document, and we know how to read this document. And let's meet some people, okay? This is Rita. This is Rita Enos. Rita is a student at the University of California at San Diego. She's from the Northern Mariana Islands. Last month, her sorority participated in a beer run in Ensenada, Mexico. During the festivities, Rita lost her ID. So she returned to the United States in the trunk of her friend's car. Rita is very concerned that she will be discovered because her passport was stamped on the way out of the United States. Okay. Rita has walked into your office. Rita has walked into your office. Okay? She's scared. She's going to get in trouble. What is our threshold question here? What is our threshold question here? I'll give you another way of looking at our Rita question. I'll give you another way of looking at our Rita question. Tell me why Rita has little to be concerned about. I want you to put me on pause and answer the question why Rita has little to be concerned about. Rita shouldn't worry because. Rita shouldn't worry because. Okay, so you were supposed to answer why Rita shouldn't worry. Rita shouldn't worry because she's from the Northern Mariana Islands. Rita is a national of the United States. Rita is a national of the United States. Does that help us get closer to our threshold question when someone walks into our office? Let's see. Let's meet another friend. Let's meet another friend. This is Anil Seth. Anil was born in India. He's been working in the US for 15 years, but recently retired. He's concerned, after his retirement, he has become concerned that he will be required to leave the US. What is our threshold question? What's the first thing we need to determine with respect to Anil? Write it down. Write down what question you would ask first. The first question you would ask of Anil. You should be writing all of this in blue, by the way. Assuming that you're representing yourself in blue, write it in blue. Write it in the color for yourself. And let's meet one more friend. This is Jin. Jin is a citizen of Canada, and she's the primary income generator in her family. A long battle with cancer has rendered her unable to meet her family's basic needs, so they applied for and were granted healthcare, housing, and food benefits for indigent people from their state. But now, Jin is concerned that she may have to leave the United States. What is the threshold question that we need to ask Jin? What's the first question? Let's write that one down. Let's go back to Rita. Okay. I will say this, there are immigration crimes that are entry and re-entry without inspection. And so I suggest that you go and take a look at those provisions, those entry and re-entry without inspection provisions, to see if Rita does indeed have anything to worry about. But Rita is a national of the United States. She doesn't have anything to worry about. And what she helps us remember is that our threshold question, the first question we ask is, are you a citizen or national of the United States? Rita would say yes. And therefore, she has no deportation, inadmissibility concerns. She cannot be removed from the United States. Anil. Again, what is the first question we need to ask him? What we know about him is that he was born in India and that he's been in the United States for 15 years working. We know nothing about his immigration status. So our first question, are you a citizen or national of the United States? Okay? Are you a citizen or national of the United States? If the answer is yes, he cannot be removed. What about Jen? Ooh, we know that Jen is a citizen of Canada. So what is our threshold question for Jen? Our threshold question for Jen remains, are you a citizen of the United States? Canadians, for example, are allowed to take foreign citizenship while keeping their Canadian citizenship. So it is wholly consistent with Jen being Canadian that she also be a citizen of the United States. And therefore our threshold question is the individual a citizen of the United States? And why is this the threshold question, guys? I've said it in lots of different ways already. Why is the citizenship of an individual a threshold question when we are having this conversation about removal or removability? You cannot be removed from the United States if you are a citizen. You cannot be removed from the United States if you are a citizen. But what if the answer is no, I'm not a citizen? Let's reconsider our friends. Same beer run to Ensenada, Mexico, from the University of California at San Diego. But now Rita is a citizen of New Zealand and only of New Zealand. Right? Now Rita is a citizen of New Zealand and only New Zealand. Okay? What do we need to ask ourselves next? Okay? What about Anil? Now, we may not know whether Anil is we may not know what Anil's, the basis of Anil's status is. We may not know where Anil is a citizen of, but now we know Anil is a lawful permanent resident. By definition, he's not a citizen of the United States, right? What are our questions now? He's been working in the US for 15 years. He recently retired. He's a lawful permanent resident. He's concerned that he'll be required to leave the United States. What are our questions now? Okay. And finally, what if Jin is just a lawful permanent resident from Canada and not a dual citizen? Right? What if she's a lawful permanent resident from Canada? Same circumstances because of cancer. She has been unable to care for her family, and so now they've been seeking indigent assistance. Okay? Put me on pause. Write the questions you think need to be answered. Let's review them one more time. Rita from New Zealand and the beer run to Mexico. LPR Anil, who has just retired. And LPR Jen, whose family is now seeking welfare benefits or receiving them. All right, so that was your last pause. Last pause of the day. Thank you for sticking it out. You do have an assignment. You do have an assignment, and when I say assignment, I mean I have something I want you to submit. What do I want you to submit? Well, before watching your next interactive lecture video, and I hope you enjoyed how we've run this, before watching your next interaction lecture video, I want you to complete the threshold question short answer. It's an assignment. Again, it'll appear in under assignments in module titled weeks 10 through 12 removal. You'll click on it and you'll find this assignment. It is a short answer question assignment. The reason that I've asked you to do the short answer questions is you'll actually be asked to do some short answer questions on the final exam, so it's a nice practice. It's also a nice training for you to boil down your answers and give me all of the critical information in the word limits or space limitations that I'll give you. Just as a preview to the assignment, you just created a list of questions that you're asking of these three individuals that we just met. What I'm going to ask you to do in those short answers is explore the INA and the provisions dealing with removability. You identified the two provisions that list out the grounds for removability, and I want you briefly to determine whether or not Anil, Jin, and Rita might be removable from the United States based on the information that you have about them. Short answer questions, do that before you watch the next video. The next video I anticipate will be released on the weekend. You will need to watch it just before class next Tuesday, which is the next time we'll see each other. On that day, on that Tuesday, I'll ask you to bring the class notes from this class and the class notes from our next lecture, and the submission will be made online. Again, you only have to submit it online before the date I'll ask you to submit it is by before class on Tuesday. I expect you will have submitted it before you watch the video, the next lecture video. Indeed, I may limit or restrict your ability to view the second video until you've submitted the assignment. Don't worry, all of this information will be in prep tasks, your one-stop shop for knowing what you need to keep up on in immigration. Thank you. I had a good time. I hope you did too. Now I'm going to walk around and push stop.